So, good morning. We're going to be talking about how to deal with the bank balance, the cash at bank pre-appointment, and looking at some of the ethical and legal guidance that you should be following in the light of recent guidance. So these are the points I'm going to be talking about. I'll be starting by looking at what the problem is, looking at how it came about and what it originally stated, what the original terms are of FAQ 10 as we now know it, and how they have changed with the reissue of FAQ 10 last Thursday. I'm then going to be telling you a bit of a spoiler alert here, why it is that I think you can ignore FAQ 10, and I'll be giving you the reasons for saying why I think you can ignore it, based on the legal authority under which it was issued, and actually its consistency, its relationship with the pre-existing law and practice. And I'm also going to say why I think not only can you ignore FAQ 10 as it was originally issued, but why you should ignore FAQ 10. And I'll be talking there about some of the consequences that could well occur if the profession were to follow something like FAQ 10. And I'll also be picking up those points in the context of the reissued FAQ 10 as well. So how it came about, this followed a seminar that R3 did. I must confess I haven't seen this seminar yet myself. It is available as a recording, and I suspect it probably is worth seeing. It was dealing with bounce back loans and many of the problems that arise in dealing with those in practice. And as you'd expect from an R3 seminar, there was a well-informed panel of speakers at the webinar. They were drawn mainly from the Insolvency Service and the Secretary of State's department, including the British Business Bank, which is actually owned by the Secretary of State, and was also a representative of UK Finance, who represent the banking and finance industry. And it's probably worth just having a look at the relationship between the British Business Bank, which of course is the organisation that has issued the guarantees for the bounce back loans. The British Business Bank is a wholly owned subsidiary of the Department of Business, Energy and Industrial Strategy, which is really just another word for the Secretary of State. And the Insolvency Service as well is part of the same department. So it was very much government speakers at this particular seminar, and I've been asked to emphasise that R3 were just providing the platform for this particular webinar. The views expressed were not those of R3; they were those of the speakers. The particular problem here is in the questions and answers, the FAQs that were published on the R3 website at the end of July. And again, these were questions that were answered by the speakers at the presentation. They were not R3's answers. And the one in particular that caused a lot of interest was FAQ 10, and the key point of that was it seemed to be suggesting that it would be ethically wrong for insolvency practitioners to advise the director to transfer the cash at bank into the insolvency practitioner's own client account pre-liquidation. And of course, this is established custom and practice, and has been for a very, very long time. Now, I don't want to set up a straw man here. I don't want to be arguing about or discussing the point out of context. So I thought it's quite important to put the complete FAQ 10 up on screen. So it's there as part of this presentation. So that is the full wording of the question and the answer. Now, Last Thursday, the 9th of September, this guidance was withdrawn and it was replaced. And the new guidance says that the banks have got exactly the same right of set-off for bounce-back loans as they do for any other debt. And I regard that as completely uncontroversial. I don't have any difficulty with that whatsoever. And there was also a statement published by the RPBs as part of the new FAQ 10 that said that insolvency practitioners must comply with the Insolvency Code of Ethics, should use their judgment, and in appropriate cases consider seeking independent advice. And that was done in the context of the RPBs noting the revised response. And again, because I don't want to be talking about a straw man here, because I don't want this to be taken out of context, this is the revised FAQ 10, and the note at the bottom is a joint statement from the RPBs. One of the interesting parts about this is the opening statement there, where the RPBs have noted the revised guidance, and that, of course, you can only note the revised guidance in the context of being aware of the original guidance and what it said, and the context of it. So as a pedantic lawyer, we're always looking for gaps into which somebody could stick a crowbar. And the fact that the new FAQ 10 refers back to the fact that there was prior guidance actually helps to keep that prior guidance alive, which I'm not sure is entirely helpful and probably wasn't intended. Okay, I'll move on to explain why you can ignore FAQ 10. And I'm going to start by looking at just how authoritative it is. And what I mean here is that there are some instructions that are given which are no more than guidance, which are just suggestions as to what we should be doing. And other instructions are intended to be mandatory. They're given under a power of compulsion, and there are consequences for failing to comply. And if you like, there's a sort of grey line in the middle where guidance passes from a suggestion as to what you should be doing and actually becomes something that's mandatory and something where you could be punished for not doing it. And in deciding whether you're going to follow guidance or not, we'll always think about the reasons why we should follow the guidance. And there may be good reasons for the guidance that we're being asked to follow, or there may be bad reasons. And in cases where there is a good reason, really good reason for doing something that has the power of compulsion, like, for example, the guidance that you should stop at a red traffic light, that's an easy decision because there's plenty of good reasons for doing that. You sometimes find, of course, and we can all think of examples of authoritarian regimes from examples in history or currently around the world, where people are compelled to do things for really quite bad reasons, and that can present people with a difficult ethical or moral dilemma about whether to follow the instructions that are being given to them, even though the reasons for being asked to do them are very, very bad. If something is being suggested to you and there are some good reasons for doing it, but there's no power of compulsion, you of course have a choice as to whether to do it or not. And depending upon the personal inconvenience and cost of complying with it, it may be a difficult decision to do. If you're being asked to do something and there is no power of compulsion, and the reasons for doing it are really bad reasons, then it becomes a bit of an easier decision because you listen to the guidance, you take account of the fact that this is something that you're being asked to do, and you can see that actually doing it wouldn't be sensible, and you just decide not to do it. And that is where I suggest the original version of FAQ 10 fell, that there was very little real authority behind it. The people who were presenting it were well informed and influential, but they didn't have any legal power of compulsion behind them in the way that they made the suggestion. And I think it was a flawed suggestion for legal reasons and for practical reasons. And I'll talk about that in a bit more detail later. The revised FAQ 10, I think, possibly because it's an instruction to follow the Insolvency Guide of Ethics, which we're obliged to do anyway, that does have some binding power behind it. And the reasons for complying with the Insolvency Code of Ethics are generally good reasons, but it's now been so diluted and watered down, it is only a faint version of what it was originally. So that's where I think the new FAQ 10 stands in all of this, that it is something that you should follow, but it's a bit like motherhood and apple pie. It is so vague and non-specific that I don't think it's going to cause much of a problem about how you should comply with it. As a practical suggestion, at the end of this, I'll be suggesting the text of a file note that you can perhaps adopt as a way of ensuring that you are documenting compliance with FAQ 10 in its revised form. So that's dealing with the legal authority behind FAQ 10 and why let me unpack that in a little more detail and explain why I think FAQ 10 has been issued without the power of compulsion. And this really is simply because the Secretary of State does not have the power simply to create ethical rules by decree. And that's some pretty fundamental principles there. There is the principle of the rule of law, which is that the government is itself not above the law, has to follow the law. And legal historians regard Magna Carta in 1215 as being the document that established that principle in English law. And in fact, here's a screenshot of the government's own website, which sets out specifically that the sovereign and their government are not above the law, and that Magna Carta, June 1215, was the first document to put in writing that limit on royal authority. And of course, the Secretary of State is the agent of the sovereign. The authority that the Secretary of State has is a delegated power from the sovereign in legal theory, which is why this is relevant. Now, I'm not going to bang on much about Magna Carta because most of it was actually repealed by the Statute Law Revision Act in 1863, and very few people noticed at the time. But the principle of the rule of law is an important one. Now, I'm not saying that the Secretary of State doesn't have the power to make ethical rules. Of course they do, and that power is in the Insolvency Act. But the Secretary of State has to follow a procedure to make ethical rules. And that starts with a draft proposal, and they have to consult the RPBs about that draft proposal, and they have to explain why the proposal is needed, what the problem is that the proposal is intended to solve, and how it will solve it. And they have to give the RPBs time to consider that and to make representations. Now, the RPBs, as the individual regulators of the members of the profession, have themselves got legal duties about how to deal with that. And for them to avoid challenge by judicial review, they really should consult their own membership, those that they regulate, about the proposals and the reasons, to find out what all of us think about the proposed new ethical rule. And FAQ 10 was issued completely outside that statutory procedure. There were no proper reasons given to justify it, and there was no prior consultation. And thinking back to the diagram I put up at the outset that shows the relationship between the British Business Bank, the Secretary of State, the Insolvency Service, you can see that there could be a suggestion of exposure to conflicts of interest in how it was issued and the means by which it was issued. So procedurally, FAQ 10 is issued in a way that should make it non-binding. And On top of that, and I will say a bit more about this in a minute or two, as originally published, it does appear actually to conflict with established law and practice, and to create a real possibility of consequences that simply are not in the public interest. So for all of those reasons, if FAQ 10 was intended to be a binding ethical statement, it would have been horribly vulnerable to judicial review. And if it was not intended to be binding, for all of these reasons, I think we can just ignore it. Now let's have a look at the revised FAQ 10 in this context. What we have there is the RPBs saying, in effect, look, there is an established, published ethical code of conduct, and that has been issued legitimately by bodies who are authorized to do so following a proper procedure of consultation. And the RPBs are simply saying, look, follow the ethical code of conduct. And they're also saying, if you need to think about your decision, then you ought to record it. And if it's a difficult decision, you ought to take advice either from within your firm or from outside, depending upon how difficult the decision is. And the subtext behind the revised FAQ, if you like, the elephant in the room, is that this follows some comments from the Secretary of State, which the RPBs probably don't really want to mention again, that has kind of suggested there may be an ethical problem if you don't help the banks actively to exercise their rights of set-off. So we all need to think about the ethics of doing that. I don't think it need be a particularly long process thinking about that. But essentially that's why I've chosen to put FAQ 10 on that particular, those two particular points on that chart. I'm now going to look at the relationship that FAQ 10 has got as originally issued with the law, because that I think will colour the extent to which we need to think about new FAQ 10 and whether that gives us a genuine ethical issue. So let's look at the law here. And I think FAQ 10 is in conflict with all sorts of fundamental principles. Professor Roy Good, in his Principles of Insolvency Law, Principles of Corporate Insolvency Law, set out 10 fundamental principles of insolvency law. And if ever you've got a feeling in your bones that something is not quite right about a new law or a court decision, then almost certainly it's because it's not consistent with one of these fundamental principles. And one of these fundamental principles is, of course, the pari passu rule, that all unsecured creditors should share equally in the funds that are available. Now, if ethically insolvency practitioners are being told to stand back and encourage one of the unsecured creditors to steal a march over the other unsecured creditors, that conflicts with the pari passu rule. Second fundamental principle is, of course, that liquidation expenses have statutory priority. They are paid first from the funds available. And of course, there are good public policy reasons to support that rule. I don't intend to say any more about that now. Another one of Good's fundamental principles is that liquidation protects the company's assets. It freezes them. It ensures that they are safeguarded so that they are available for all creditors. Taking possession of the cash at bank pre-liquidation does exactly that. It freezes the cash at bank. It ensures that it is preserved and protected and that it will not be dissipated in the last days pre-appointment or immediately post-appointment. So taking possession of the cash at bank, having it transferred into your client account, is wholly consistent with one of these fundamental principles of insolvency law. And of course, there are specific legal rules within the Insolvency Act to protect the insolvent company's assets. And I can just give examples here as the rules about preferences and transactions at an undervalue. And I'd also suggest that set-off is actually a whole lot more complicated than suggested in FAQ 10 as originally written. And we could have an entire coffee break briefing on set-off. But we have many different types of set-off. One of them is insolvency set-off, and that is a force of nature. When the company goes into liquidation, insolvency set-off then applies, and it's automatic. Nobody has any discretion about it. It's mandatory. Outside of insolvency set-off, say there are many different sorts, and for example, there's contractual set-off, and that can be much wider than insolvency set-off. So, for example, the bank might have a contractual right to set off against the cash at bank an overdraft of a joint venture company, a completely different entity. Or they may have the right to set off debts that are owed to other companies, for example, the shortfall that they anticipate that their invoice discounting subsidiary may incur. Or they may have the right to charge back credit card refunds. And if the company is known to cease trading, then there might be an awful lot of those piling in the days pre-appointment. And of course, there's always the possibility that whilst the cash at bank is still at the bank, then payments will continue to be drawn from it as standing orders, checks, direct debits continue to be processed pre-appointment and possibly sometimes even post-appointment. It shouldn't happen, but it can happen. So that's the law. I've also had a look at the existing Insolvency Code of Ethics. I've seen nothing in that to support FAQ 10. I've also had a look at the SIPs, and I think SIP 11 is inconsistent with FAQ 10. I'll say a bit about that in a minute or two. So I would say that ethically, there's actually not an awful lot of hard thinking that you need to do before advising the director to transfer the current account bank balance to your client account today. A short file note might be prudent, and at the end of this presentation, I'll give you the text of what I think you might think about as being a file note to show that you have thought about it. I mentioned SIP 11 just now. I think paragraph 6b is particularly relevant, and that says that estate money, which means the company's credit balance, has to be held by the insolvency practitioner in accounts that meet these criteria, and the account must prevent the bank from being able to consolidate that account, that credit balance, with any other credit balances or any other party's funds, and they must not be entitled, they must not be allowed to exercise any right of set-off or counterclaim against that. Now, SIP 11 probably strictly applies only from when you are appointed as liquidator, but the general policy behind the SIPs is they should also apply pre-appointment as well. And I think it is entirely reasonable. In fact, I'd say there's almost a duty on insolvency practitioners pre-appointment to make sure that they are in a position to comply with SIP 11 as soon as they are appointed. And so I think in practical terms, to comply with paragraph 6b of SIP 11, you must have the bank balance transferred into your client account pre-liquidation. And there's all sorts of reasons for that. One of them is that before the liquidation starts, the bank hold a mandate from the director, and the director has legal authority to transfer the funds. On your appointment, that mandate will be terminated, and the bank won't be able to do anything with the funds until they have got a new mandate from you as the person entitled to operate that account. And that's going to require them checking that you've been validly appointed, checking your identity, doing their other necessary checks, sending you the paperwork. You'll need to fill in the paperwork, have to send it back to them. They'll have to check it, process it, and implement it. And that's all going to take time. And during that time, the funds would still be in the company's original bank account, and they would be vulnerable to set off by the bank against other debts, against chargebacks, against any payments that have been processed immediately before appointment or even post-appointment. So if you did not transfer the funds pre-appointment, they would be at real risk of dissipation. And as I said, although the bank may be contractually entitled to set off, that contractual set off could be much, much wider than the statutory insolvency set off, which they are entitled to on liquidation. And so if they take more than they're entitled to on liquidation on the day before the company goes into liquidation, that does look rather like a preference, and is something to be prevented. So that's why you can ignore FAQ 10. I'm now going to talk about some of the practical consequences of FAQ 10, some of the practical consequences of what would happen if you were unable to transfer funds into your client account pre-appointment. One of them, of course, is that there would be the risk that funds would be dissipated, and that could result in the funds not being available to pay the legitimate expenses of liquidation. As I've already said, there are good public policy grounds why those are given priority, and why it is considered necessary for companies and company directors to get good advice from appropriately qualified people when the company is in the twilight zone. If that advice is not available, then funds could be dissipated simply because directors might not deal with the company's assets properly, and the directors could be at personal risk because they wouldn't necessarily be complying with their duties because they might not be advised to do so. And of course, nature abhors a vacuum if insolvency practitioners are unable to advise the directors to transfer the cash at bank into your client account pre-appointment to preserve it. Unregulated advisors will see an opportunity and will step in. And some of those unregulated advisors will no doubt give very pragmatic, legally correct, commercially correct advice, and will be doing all that they should. But there's also the possibility that some of them may simply be filling their boots. So that brings me back to the matrix I drew at the outset, which is why I'm saying I think there are some very bad reasons for complying with FAQ 10 as it was originally drawn, and it's also not got any authority of compulsion behind it, so I don't think you should or ought to comply with it. The revised FAQ 10 is now so dilute as to be almost meaningless, but I think probably on balance you ought to comply with it, and I think the way you should comply with it is to put a note on the file at about the same time as you send out your engagement letter. And I will circulate the text of this note as a Word document after this presentation when I circulate the link to the recording of it. So the file note will probably simply record that you have advised the director to transfer the cash at bank to your client account. The reason for doing it is to protect and preserve it and to comply with SIP 11 paragraph 6b. The file note would note that the bank, of course, may have existing rights of set-off, and they may yet exercise those rights of set-off before the funds are transferred to your client account. And as suggested by FAQ 10, you have considered the ethical implications of this advice under the Insolvency Code of Ethics. You have reflected on the circumstances and the analysis in today's briefing, and consider that no further discussions are needed on this point in these particular circumstances. Obviously, adapting that final conclusion as the situation may require. There may be circumstances where there is some ethical issue around it, but I suspect that in the vast majority of cases, there simply won't be. So I think I've taken 3 minutes longer than I said, so my apologies for that, but that's essentially what the problem is, how it arose, what the text was of FAQ 10 as originally issued, and what the revised text is of FAQ 10. And my reasons as to why I think you can ignore FAQ 10, firstly because it was issued without any binding legal authority. Secondly, because I think it conflicts with the existing law and professional guidance that you should be complying with. And thirdly, because I think if the profession were to assist banks in exercising rights of set-off pre-appointment rather than preserving bank balances for the benefit of creditors, I think there would be all sorts of adverse consequences for creditors, for the insolvency profession, and society generally. So if you have any questions, I will be very happy to try and deal with them now. I see that there's a comment come up, but I can't. That's it, I've got that open. Yes, a question here about whether there would be any change of our position if the bank has a charge over the company's assets, with the point being here that the charge would have to be a floating charge. If it were a fixed charge on the bank account, then the bank account would necessarily already be frozen and could only be operated with the consent of the bank. I would say if there's a floating charge, there is no difference, because if the floating charge has not crystallized into a fixed charge, then the bank has not taken control of the cash at bank, and so it is still free for the director to use in accordance with established custom, practice, and legal requirements. So no, I don't think my opinion would change if the bank has a floating charge over the company's assets. So with that, if there are no other questions, I will say thank you all very much. So I've got one further question, which is asking what would be the position if a fee was taken from the bank account and it was then found that the bank was in overdraft. I'm not quite sure what the context of the fee here is, whether that would be a fee to the insolvency practitioner, or whether it would be the bank themselves taking a fee that takes the account into overdraft. I suppose if the situation was that you thought there was a bank balance, the director transferred £5,000 to you, and it actually turned out that the director was drawing on an overdraft to transfer those funds, then I don't want to actually state a view here and now, I don't think, but I think there would be a problem, because effectively you would have had the director taking money from one creditor, incurring a debt specifically to pay the liquidation expenses, and I think there's at least the possibility of fraudulent trading as far as the director is concerned in all of that. Now, that may not be a problem if the director had given a personal guarantee to the overdraft, because then effectively the director is going to have to pay that themselves and the bank will not suffer the loss. But I think that is one where we'd have to be slightly more careful about that. And we have another question where the bank account was actually frozen as a result of other circumstances before the appointment took place. And in that particular case, then of course there is nobody to instruct the transfer of the funds. And I think all you can do there is probably write to the bank to say that you are about to be appointed as a liquidator, and that any payments out would be at risk of being preferences. The other option you would have possibly, I suppose, would be to get a friendly creditor, if there is one, to issue and serve a winding up petition. And then once the bank have got notice of the winding up petition, they would then have to freeze the account at that point. But of course, they would be entitled to apply insolvency set off at that. So I'm not sure there is an easy answer to that one either. I think that is now probably all of the questions. So on this, I will just say goodbye to you all, and I hope to see you next month for our talk about zombie litigation.